All right, so we're going to get going. As I said, Susan's not going to be here. She had a health problem this morning, so this is it, only four of us, which may pose problems for some people.
Should, when it's convenient, should we see who's in the audience that might want
Yeah.
to continue for another
Yeah.
month?
Yeah, I think so. So just going through the agenda, or can I get a motion to approve the agenda as written? Michael made the motion.
I'll second it.
Jim seconded. All those in favor say aye.
Aye.
So that was unanimous. So approval of the minutes of June 13th and August 8th, I think we should probably wait for a larger group of us.
I agree.
So, in case anybody had any issues, so we will pass over that matter. I think on some of these old business items, we can just quickly clean up.
Procedurally, you can have a simple majority of things that are continuances with the
Right. Okay. So on 1819, Peter L. O'Brien and Natalia V. O'Brien, 36 Low Beach Road, they'd like to continue to October 12th, 2019. Does anybody have any problem with that?
Nope.
No. So, can I get a motion?
So moved.
So Michael seconded. Any further discussion? No. All those in favor say aye.
Aye.
Okay, so then we're on to 1919, Sheila Giardini and Carmine Giardini, 7 Clifford Street. They would like to request a withdrawal without prejudice. So,
I'll make that motion.
Michael makes a motion,
Second it.
Jim seconds it. Any further discussion? No. Is anybody in the audience here to speak to that? No. All those in favor say aye. Aye. Okay. So now we get to the nitty-gritty. There are only 4 of us. You need all 4 positive votes. It's your choice whether or not you want to move forward or not. I'm addressing everybody, but we'll start with you.
Yeah, I'm ready, I'm okay to go forward.
Okay. Yeah. Okay. Well, just let me ask, if others in the room, just to be clear, you need all 4 votes for an affirmative vote. So it's your choice if you want to go forward or not. If you don't want to go forward and you don't want to sit here through those that do want to go forward, just speak up now.
Chair.
Go ahead.
There's also the possibility of a meeting in the next week or 2 for this list of possible dates as of this morning, if we want to have an additional meeting for those.
Yeah, the issue I have with that only is that there are only 4 of us here. The other 4 members can't weigh in on their schedule, so I think it's going to be difficult. But anyway, does anybody, before we get going, does anybody want to continue anything without opening?
Yes.
Arthur,
Yeah.
which one are you?
I've got the next one, 2319, and I hereby request a continuance, ideally until next week, if a date can be set for them. Otherwise, the next available time for a meeting, in order to enable having a full board.
Okay, well, let's discuss this. I will not be here Thursday or Friday of next week.
Neither will I.
We don't know anybody else's schedule.
I'm going to assume that Susan's here, her children are in school, and she has to practice. I don't believe she's leaving. I don't know. Lisa, I reached out to, I think she'll be back from her trip. I hadn't heard from her, but I did reach out. And Karen's out of the country, and I don't know when.
All right, so what's the
I don't have a
board's
problem.
pleasure? Do we want to go to another date? Do we want to go to October?
As soon as we could do it would be Tuesday for posting purposes.
What do you think?
I can be here the 17th, but I cannot be here after that.
For that week, yeah.
The following week, I think I'm free, so.
I mean, the room is available. Let's say Well, what do you think?
What's the date?
17th.
Well, one option would be Tuesday the 17th. Another option would be any day, let's say, of the following week. Although I would not be available Thursday or Friday of that week either. So,
Tuesday the 17th, I could be available after 2 o'clock in the afternoon.
It's only available 8 to 12.
No,
okay, so scratch the 17th. Let's not belabor that point. Jeff, you're not available the 18th.
Nope.
So those are out. The 19th's out. The 20th's out. So we're on to the next week. 23rd, 24th, 25th. I'm not available the 26th or 27th.
You know, to make it easier for everybody, I know you're wrestling with the dates, and I'd like to get this done sooner rather than later, but obviously with a full board. I'm perfectly amenable, rather than tying your schedules up in knots, to request a continuance until the regular October meeting.
That works for me. Having said that, just FYI, 2 of us won't be here for that, Lisa and I. But anyway,
Well,
okay.
we'll take our chances.
Yeah. I think it's
And what's the date of the?
October 12th, 10th.
Okay. I get back the 9th, so.
Yeah. All right. So back to 20. We're going to just skip to 2319. You're requesting a continuance without opening to the October 10th meeting. Thank
Right.
you. All right. Does anybody have a problem with that?
Nope.
Can someone make a motion?
Make that motion.
Michael makes a motion. Jeff seconds it. Any further discussion? No. All those in favor say aye. Aye. Okay.
Aye.
Thank you.
Thank you very much.
Nobody else wants to get out of here? Okay. Go ahead, John.
John Brescher?
Yes.
In the event that one were to open an application, could a fifth member mull in at the next hearing?
Could.
Or just,
I don't know, I've never seen anything in fine print that indicates that that is not acceptable.
Yeah, I'm going to go out there and say that it's not the preferred method.
no,
The preferred method would be to have everyone here
of course.
for the initial public hearing. What do you think about that, Michael?
No,
Well, I would say this, I guess the applicant assumes that we're not gonna vote on it today.
Right.
Or either that, or he's gonna ask that we not vote on it today.
in such an instance. Okay, I was just,
I mean, I thought of that on my way. I mean, we could, even if they ask that we don't vote, but feel like ready to vote, we still could.
Mm-hmm.
So I mean, I guess it's up to the applicant, but, anyway, let's, if you're not ready to continue, let's.
I'll let Mr.
Yeah,
Glidden
let
first.
Mr. Glidden proceed. 2219, Richard J. Glidden, trustee for the Forest Shakamo Road Realty Trust, Forest Shakamo Road.
Thank you, sir. The last meeting was continued because this is a pre-existing situation, and we have 2,110 square feet of existing ground cover. We're going to do renovations and demolitions, and we didn't have the final plan, so there was concern that maybe at the end of the day, we were going to still have some or all of the structures in the setback. We still don't have the final plans, but we have confirmed that at the end of the day, we will have not more than 2,110 square feet, and no structures will violate any setback requirements. Whatever there, if there's something there that violates now, it'll be moved or demolished, and everything new will be within the setback. So I think that's what you were looking for. That's what I was looking for, anyhow. Thank
Yep.
you.
Okay. Is anybody here to speak to this? No. So it seems pretty straightforward now. They're just keeping the ground cover they have. You okay with it?
Something we've approved before.
Yeah.
Were all 4 of us on that? I'm sure we were.
I was here.
Yes, it was, Ed and Michael and Jim were at the table, and Jeff was also at the table.
Okay.
Lisa had a conflict. Yeah, so I don't have a problem with it. Jim?
No, I'm fine with it.
All right. So it'll be, as Dick stated, everything will be conforming other than the blessed ground cover.
With a maximum of 210 feet.
Right,
2110.
2110. Okay?
Yep. I would make that motion to approve that.
Okay. Michael seconds it. Any further discussion? No. All those in favor say aye. Aye. Okay. Thank you. All righty. So now we are on to
2419.
2419. This is 26 Sesapena Road. With Mr. Brescher. What do you want to do?
I have a question before Mr. Brescher answers,
Go ahead.
and maybe Eleanor cares to answer this. If you don't, that's fine. Do you think that going with a four-member board without the applicant having the real owner, the beneficiary of the application, knowing, agreeing to a four-member board, that the board is at risk?
I think the applicant has turned his life over to his attorney.
I think so,
That's
too.
signed off,
Just a question.
and then we have no control of this.
Yeah?
There's not anybody messing up or.
Well, I would think that the applicant's rights in a court of law against this board are diminished because their spokesperson made the decision without,
Right, but that's not on us,
I agree.
so that's my answer. So go for it.
Yeah, thanks. All right. With that in mind, for what it's worth, I did actually try to reach the applicants and let them know with this four-member board, and asked if they were comfortable moving forward or not. I have not heard back from them.
We'll put that in the record.
Yeah, thank you, thank you. Not to punt, but it might make more sense just to continue for a full board, just on the off chance, especially if there's questions about the Mullen rule. I mean, might.
You know, the
so-
Mullen rule probably is okay. It's just not the preferred method.
I,
I feel like we've done it before.
We've never did started with four
For-
with the intention of mullening in. No.
No, but that's true, but I think there's been a situation where we had five and one person wasn't there subsequently and someone volunteered
Oh, yeah, no doubt.
who hadn't been there.
as excited as we all would be to make case law, I don't
It's a
really feel
reverse Mullen.
like doing that, if that's all the same.
Yeah, it's
Um,
a reverse mullen. All right, so you want to continue to October 10th?
Yes, unless there's any inclination doing one earlier, but October 10th is fine.
Without a.
Without opening, please.
Okay.
Absolutely.
So somebody want to make that motion?
I'll make that motion.
Second.
Jim seconds it. Any further discussion? No. All those in favor say aye. Aye. Thank you.
Thank you.
Okay, this could be a record day. 2519, Jane DiBiasio and Brian DiBiasio, 39 Meadowview Drive.
It's supposed to be Williams?
Okay, they're not here. We're moving on. We'll come back if we need to. So now we're on to other business, right?
Yeah.
5103. But
Anybody there for this?
there's nobody for this either, and I did get correspondence. I don't know if everybody got it, but it sounded to me that the parties are in discussion. So it might be premature for us, or I don't think there's anything further for us to discuss until they finished their discussions. Is that a fair summary?
I do not want to represent how the non-resident group feels about that. My understanding is that they want this resolved as soon as possible, meaning they want you to help facilitate things happening expeditiously. There's concern that there's some foot dragging, I believe, and
Well, I, for one, am not gonna go out on a limb with the four of us,
Not for this.
no. So whether or not they want us to step in or not, I don't think it's appropriate personally. And nobody else has read the.
Not without any else being here, certainly.
Right. Well, I'm just saying, I mean, are they coming?
she's supposed to. They're supposed to be here. I mean, I did email about the situation with four-member board, all the representatives who were supposed to attend today. All I can do is get them.
No, I agree.
Here comes.
All right, well, we'll go back to Linda and, application, and then we'll move on. Well, there's only four of us, and, so you're up. There's only a four-member board. The other applicants have decided to continue, it's up to you.
We're fine. I left my drink out there, but whatever.
You left your drink out there, okay?
Just running.
So you're, 2519, Jane DiBiasio.
Yep.
Brian DiBiasio, 39 Meadowview Drive. You want to move forward?
Yeah.
Okay.
This is sort of a no-brainer kind of
Yeah.
thing.
Go ahead.
It's just validating the survey so they can get a CO on this building. There were some differences of inches, 2 inches here, 3 inches here, 4 inches here. It's still not over anything more than what the board granted them before, so we just sort of want to validate where this building is now.
Well, it was over the height.
Well, it's not over the height allowance, but it's 6 inches over the height that was in the decision, which we don't usually do that, but this is just a studio. Since then, they've got sewer and water down there. And it's still not going to be a secondary dwelling. They don't want a secondary dwelling. They just want it to be their studio and just sort of hang there. It's 3 inches off on the height. It's 2 inches, 1.5 inches off, and it's still outside the 5 foot, which is what you granted them in the previous decision. So you just want to validate what it is and allow plumbing in the building, I believe.
No, they have plumbing in the building. They
They
want
do.
to have tubs in the building or showers now.
Yeah, which they can do now because they're not on septic anymore. So the
don't
health
think that
department
had
doesn't have a
anything to do
problem.
I don't think it does
That
either.
had nothing to do with it. For some reason, the board at the time restricted it to half baths, but it had nothing to do with it.
Well, it did, as far as the ones I've done in Nantucket. You couldn't have a tub, you can have a toilet and a sink, but you couldn't have a shower or a tub because they were not on town water and town sewer, but now it's on town water, town sewer, so the health department doesn't care what you put in there. And the building department didn't care, so I think things have changed. It was definitely in the wetlands, and it was definitely on well and septic, but that's changed since this was done.
Again,
Which
that's
is-
not my recollection
No,
of why we.
I'm just thinking here. So, I guess the issue's always been, when you've got a studio, you know, why do you need a bathroom? Well, you need a bathroom because it could be an office, and then why do you need a shower? Well, it could be a gym.
And the building department doesn't care now.
Yeah, and then it's the question of, well, it was on septic, and it was a 3-bedroom septic, and, you know, there were three bedrooms, and now if this is used as a 4th bedroom, it's violating the septic, and now that it's on the sewer, I'm not sure exactly how the people in the town building department feel about it.
They don't care.
But I've never seen anything in writing that condones a shower or a tub because it's not on septic anymore.
It still says not for human habitation, and that's
Okay.
going to stay there.
And I've talked to Paul about that.
If I may, through you, Mr. Chair? The
Please.
definition of studio, I believe your current is studio garage.
Yeah,
At the time.
that's what it was. It is.
The definition of studio doesn't address call-out plumbing, it just says a building or a room or rooms, can you hear me, Terry? Or rooms where an artist, artisan, photographer, or the like does his or her work.
And all the studios I've done
Occasionally,
lately have showers and tubs.
Only when they need a nap. Like I sleep at my desk sometimes. As long as you're sitting up, it's okay.
Pretend.
Well, we definitely have in the past approved studios with showers. So let's just go through the checklist, because they want that condition removed. B,
Yeah.
the footprint, it was actually larger than what we approved before. I don't remember why, did I sit on this?
This
We
is a
would've-
while ago.
Well, we would have restricted it to a specific number because that's what they applied for.
Yeah, 11, 8 years ago. And that's what they did apply for, but when they built it, it's still the same inside.
It got
Something
wet and
happened.
expanded,
How much?
13 square feet.
582 to 595.
so 13 feet.
Okay.
13 square feet,
That doesn't bother me.
which
No,
is the
okay.
circumference of the building.
Circumference of the building is not, but-
23.3 feet instead of 23 feet. An increase of 3.5 inches, and then it's 5.3 feet instead of 5.5 feet. And according to Blackwell, it's 1.5 inches, but still outside the 5 foot, which is what you reduced it to from 10 to 5.
Yeah, it's still outside the 5, so.
That's pretty minimal compared to some of the ones I've seen.
Does anybody else in the audience want to speak about this? No. All right, I don't have a fundamental problem with it.
Let's vote.
So, basically, we would be granting the relief requested.
With no further, I would.
The other conditions stay in place.
In terms of the setback issue, we don't want them to then think it's okay to then go.
No,
bend the setback.
Certainly not.
No, we don't,
Certainly
just to
not.
validate the structure.
because as we talked, they could go the whole line.
Nope, just to validate the existing structure. That's it.
I mean, I always have a problem with this. I don't understand, this was just 7 years ago, we put restrictions on it.
Watch out, my stuff is
And
underneath.
3 of the 4 weren't complied with technically. But why, you know,
Well,
I don't
no,
know.
B, I don't think, well, if they're asking for, they're not asking for forgiveness, they're telling us it's not in yet.
yeah.
They'd
And
like to
right,
add
The
a
other
shower.
2.
Now, whether or not we went in that building and didn't see a tub, who knows, but the
I
other
mean, we're
two-
talking about 1 inch, 1.5 inches, and 3 inches everywhere else. I mean, that could be simply a grade change difference. We've been trying to get a height.
No,
tack on
what
it for a
Jim's
while.
saying is if you know you were supposed to be at 5.5, and I'm not blaming you, Linda, why wouldn't you make it 5.9? So you actually have wiggle room. People are just.
They didn't build it themselves, so I can't account for that. It could be the width of a shingle, as we
They're
know.
responsible, so it's
Yeah.
not the width of a shingle. Last I checked, the shingles aren't an inch and a half thick, but, having said that, it's a pretty de minimis,
And it's a special permit, not a variance.
I mean, you know, and it still stays not for human habitations.
Mhm.
Yeah. And it is, you know, there were extenuating circumstances vis-à-vis the, wetland.
Yeah, they were hemmed in there pretty good.
So, does somebody want to make a motion to grant the relief requested with the condition that no further expansion?
No further extension, and the remainder of the relief remains in full force and effect.
Right.
Yeah.
So moved.
Okay. You want to second that one?
Sure.
All right, Michael seconds it. Any further discussion? No. All those in favor say aye. Aye.
Aye.
Thanks, guys.
4-0, thank
I
you.
wish they were all 1.5 inches.
Okay, so now we're back to the, to the Rugged Scott matter, I guess, 5103. You have anything to tell us? Somebody? Says, for the Holland, Posner, and Haverty.
Right. Don't see Mr. Posner or Mr. Haverty.
Nor do I.
Tucker Holland, just here as a resident in the area. So I first want to thank the ZBA for their attention to this matter. I can report that we did have the opportunity to meet with Mr. Posner and two of the residents of Beach Plum Village, the Plandowskis, as well as Robin Halleck, who works for Mr. Posner. This morning, Peter McEachran, Chris Young, Bert Turner, and myself. And I would say that it was productive certainly to have a conversation. There seems to be quite a gulf in the interpretation of including this program. Mr. Posner made clear it really isn't his first choice to do this. However, it seems like there may be an opportunity for us to, talk a bit further. One aspect that just, to us anyway, seems to fly in the face of the whole inclusion of this non-resident membership is the idea of paying an initiation fee, and that Mr. Posner had indicated maybe on the order of $33,000. So I'm not sure that was really the intent of the ZBA when this provision was originally included, and we're hoping with a little further conversation we might arrive at a more reasonable approach to all of this. So I'm happy to add whatever I can. I'm sure the Plandowskis could add as well. Peter McEachran is here. But, we simply would like to see, this program that we believe was intended to be sort of a community benefit due to the development of this project in the neighborhood, to be implemented 13 years later as it was originally intended. I think it was a helpful opportunity, I think, for the Plandowskis to be able to meet some of the folks in the neighborhood who are residents on Sakenau and vice versa. And so we're hopeful that we might be able to get this put into place before too long here.
Okay. Do we have any questions for Tucker?
I didn't sit on this 10 years ago, 12 years ago, but I would expect that Posner is entitled to some type of yearly fee for membership, but I'd like to see what was discussed at meetings 10 or 12 years ago regarding a fee to join. And maybe Tucker can answer that. Is there anything mentioned in any minutes or?
I mean, we haven't gone through extensive, review of all the old discussions. I mean, Bert Turner was there and could share that the Great Harbor Yacht Club, you all may be familiar, has off-site pool and tennis facility, and in a somewhat similar fashion, I think they were required to provide some memberships to the year-round community that very much, I mean, I don't think anyone disputes at all that there shouldn't be some yearly fee, commensurate with what the homeowners in Beach Plum Village pay, and, but reflective of, if Mr. Poser had indicated there would be more restrictions on the non-resident memberships than, if you will, the memberships of the year-round owners, but that the pricing would be the same, which seems a little difficult to get your head around. But absolutely, everyone would expect there's some kind of annual dues. I think it's the initiation fee that was a bit of a unexpected twist, and it was mentioning that Mr. Turner had shared in the case of the Great Harbor program, there's no initiation fee, but there is an annual dues structure. So that's what we would expect.
Mr. Chair,
Yes.
you all have this in your packet, but,
Yeah.
and I don't know what page it's on, but the highlighted language,
I have it.
condition.
205.
Right.
So was there initiation fee on the other members of the community? I doubt it.
My name's Ruth Plandowski, and I've been living at Beach Plum since 2008.
Can you speak a little bit more into the mic? Thank you.
Okay. Ruth Plandowski. We bought a home in Beach Plum in 2008. To answer your question about an initiation fee, that would have been a part of the purchase of our homes. The amenities were outlined, and when we bought a home there, we have no choice but to be a member of the HOA there, and the amenities are built in to the cost of purchasing homes, which the neighbors, if they eventually participate in the use of the amenities, have not done. So those figures, there were considerable costs in providing those amenities, and those would have been built in to the costs of charging and fixing prices for the homes there. And I think that's the expectation, is that some kind of capital expense payment would be contributed by people who did not buy homes in the area, but then come in to be a member and have full use of all of the amenities, which include the clubhouse, which now houses a small gym, the pool, the tennis court, and a park with a bocce ball court. So those all had to be paid for, and in the end, basically, those home prices were charged to pay for that.
Thank you.
Okay.
Does anybody have any questions specific to that? No? Is it fair to say that negotiations are ongoing?
Well, yeah. So I'm looking at nods from the Plandowskis. Yes. I had to leave the meeting a little bit before it formally ended, but there was certainly a difference of view on the initiation fee aspect. But I think we'd love to figure it out if that's what the intention of the homeowners is.
Well, my inclination would be to have you take the negotiations further before we get involved, if we get involved at all. How does everyone else feel?
I like that
Oh, I
approach.
agree.
And I don't, so,
Well,
go
Just
ahead.
as the notion of the non-resident people having to pay it, some sort of an initiation fee, to me doesn't seem reasonable. I don't think that was the intent when this was originally done. A yearly maintenance type of a fee, a yearly fee associated with the ongoing use of it, but a fee to pay for the work, I think that was the developer's expense, and I think it should be maintenance's expense.
Yeah, I agree with Michael that we probably need to see more information on the discussions that went on, but I would agree with you, Jeff,
Has
that,
anyone
I think
ever
that would be
seen any?
specifically
I don't think
in,
that was ever,
I think this was linkage, basically.
Josh is,
Okay, let's hear from you.
we're talking about this now.
Can I just ask a question, Ed?
Sure.
Was there any?
Just identify yourself.
Oh, sorry, Jill Veith, Nantucket resident. I just wanted.
I didn't hear you.
Jill Veith.
Oh, thank you.
I just wanted to know, was there anything in the permit that you gave that had a timeline on it? So it's just a question about it, just the process.
I'm reading it, and I would say no. But I'd have to read the whole decision again to see if there was maybe Tucker knows better, because you've probably pored over this, but is there,
Honestly, I
Time
haven't.
used?
I mean, I was made aware, my wife and I bought a home on Sacanau last year, and I was made aware a few months ago in the supermarket by another year-round resident. It was like, oh, I'm sure when you bought your house, it wasn't lost on you that this sort of provision exists. And I'm like, I don't know a thing about it. And so I began to look into it, and I just sort of thought, I'm certainly hoping that we could, maybe it's taken some time to get implemented, but maybe we're at a juncture where the intention, if it's there, to properly implement it in the spirit in which we believe it originally was part of the permit and settlement agreement, then there doesn't need to be a whole lot of anyone's time invested. But to the extent that unreasonable provisions or further delays are going to be a part of it, then I guess we got to dig into everything.
okay, but Josh, did you want to talk specifically about this?
First of all, I'm very sorry not to have been here on time. I thought we
Well-
were last on the agenda, and
We're,
I was getting here a couple of hours early.
no worries. We don't.
You are here.
You are. It's not. That's not on you. We have an accelerated
Okay.
thing going on.
If only that could happen every month, right?
Okay, you're telling us.
Now that Mr. Toole is the former chairman, he doesn't really care about time anyway.
Go ahead.
So I don't know what the conversation has been exactly, but I'll try and be summary and brief. I sent a memo outlining our approach. I've been in touch with Tucker and the other people in his email chain going back to April. Things took a little bit longer to get back because of my health adventure over the summer. But we met this morning, and I am looking forward to meeting again with the neighbors. And it may be possible to work something out. It may not be, but I think that that's where we should be trying to get. The one thing I do want to say is that from our perspective, we always saw this as something that would be done at the end of the project, when the owners who were affected by how this would be structured could be involved in determining, is the offer going to be made to 10 neighbors or 30 neighbors, and on what basis? And so we've been having informal meetings with the owners for quite a few years. It was a big agenda topic a year ago, and it was another big agenda topic just last month when we met. So I think we're ready to move forward with something. and look forward to doing our best to work it out with the neighbors, and if we can't, you know, we'll take the next steps at that point.
Okay.
I have a question.
Go ahead.
For Josh, if you know the answer. Do you know of any document that exists that specifically mentions an initiation fee for the neighbors?
No, and I don't think there is one. I think that what there is this statement in the condition that says that the neighbors would pay on a comparable basis with the owners.
So, yeah, it says,
Comparable fee structure.
right.
Yeah,
You know.
You know, from a guidance standpoint, maybe, my view on this is absent something in the record from that time. I don't think this contemplated a initiation fee. That, to me, it's the ongoing
It's a maintenance
comparable
type of fee, an ongoing
So,
fee. I agree.
That's kind of where I come down on it, if that helps them in their discussions. I don't know if anybody feels that way.
Yeah. I could go either way, frankly, on the initiation, because
I agree with you on that.
you do get the benefit of, so you do get the benefit of all the amenities that were paid for. But, I mean, obviously, it depends on the number, too. But anyway, I mean, until we have
Back to
more
the Great Harvey Yacht Club, I mean, there was no initiation fee.
for the neighbors.
Absolutely not.
And I agree with
Absolutely
you.
not. There was a
but I
yearly
think it-
fee you could pay, but there was no initiation.
I agree with you. I think it would have been addressed specifically if there was an initiation fee on top of this, somehow addressed in this, but.
I mean, the
I mean, is there
the
initiation
homeowners
fee for the
association, to some
homeowners?
degree, is getting a benefit by,
Right.
just having the potential outside members pay the same homeowners association number, if that were a solution, because they are only, you know, some of that homeowners association money is going towards other upkeep.
Other things,
It's not
sure, of
just the
course.
maintenance of this stuff. So, my feeling is, they're working on it,
Right.
and let's wait and see if we really need to be further involved.
Mr. Chair, one other thing I want to point out, I'm sure you noticed it, on page 11 of the comp permit, the 2 pages prior to where that condition is, that condition is under section 3.2, management issues. The heading of 3.2 says the following conditions and rules and regulations shall be binding upon the owners, the occupants, and the association under the authority of the association, its agents, designees, and assignees.
So what are you trying to tell me?
The way I read that, and I will leave it to you, the way I read that is that the enforcing and the authority to make those determinations is the association and the members who have the right to vote on how they handle it. It has to be handled, but it's up to them.
Yeah, I think, you know, I hope it all works out. The language is relatively vague, but we've just gone through this, and it's hard to get every contingency thought of and worded to the extent it might need to be. So my hope is that you guys work it out. And until we get to a place where you're not going to work it out, that's when we would potentially get involved. Right?
Question, Eleanor, did you talk to Marcus about, you know, what's the zoning enforcement officer's role in this? Do we-
I did not talk to Marcus.
Okay. I mean, we're not there, I'm just wondering.
He has received a letter signed by Ed,
Yeah.
which was carrying forth your recommendation last month.
Yeah.
And I know that he received it, but I have not had further conversation.
Nor have I. I wrote the letter as the secretary because Susan felt conflicted. So,
Just out of curiosity, has anyone consulted with the chairman at the time this was in front of the board, which is like 12 years ago?
Yeah, oh,
I'd be
Who was
curious.
that, Edward?
Edward Sanford, see what his recollection
yeah,
is.
I have not.
Might be worth it.
My feeling is it could be a win-win, but, you know, and hopefully
It cuts
can be
both
worked
ways,
out. And,
Mr. Chairman. I mean, without getting totally into it, it cuts both ways. Certainly, the owners recognize that their common charges could be subsidized in a sense by revenues coming from neighbors. At the same time, the pool is already very busy and on a hot summer day. And there seems to be pretty unanimous view that that's an issue, that's a bigger issue. So more people versus some money, but that's the trade-off.
I mean, maybe in the interim, somebody can dive into the minutes or something. I mean, the minutes probably won't tell much. Did we even record things at that time?
I have been through the minutes for other reasons, and
They're pretty vague.
Oh, there are definitely minutes on that.
Well, I know they're minutes, but they're,
there are minutes, and I have them, but,
They were recorded as well by a machine.
yeah, Jake,
Yeah.
With
I'm
that
not
being said,
volunteering
it's-
to go through the tapes. Just to be clear.
I mean, it's gotta get worked out one way or the other. It's in, I mean, it's a part of the comprehensive permit. It's gotta be figured out. Whether,
Let's put it this way, I don't think the intention was to, if they put this in here, I don't think the intention was to say, you can be a member for $100,000 or a $30,000 initiation fee. So, yeah, maybe there's some reasonable ground, but I don't think it was that. But that's just me.
How many homes would have the ability to participate that are outside of the subdivision?
I have not counted it up exactly, but I think it's only around 30.
30.
Well, it's a maximum of 30.
Well, there's a there's
Yeah,
a
we
maximum
had
of
a
30
map
that could be
at one point
offered,
that
but it's,
showed-
Yeah, I saw
Right.
it, but I never
I
counted.
never.
yeah, our plan would be to count and to get all the addresses, and once we figured out what the terms and cost and fee structure would be, we would write to all of them at once and offer them all an opportunity, and it would be first come, first served.
All right, so what do we want to do? Ask you to come back later, telling us everything's worked out?
Yep.
'Cause that's
So,
what I'd like.
Just a question on what you just said, first come, first served. If there's 30 properties that have potential access, and they all wanted access, are they all entitled to go in the same year?
No,
No. You can limit it,
we can limit it to 10.
10.
And the notion on the part of the owners is they would like to limit it to 10.
That, to me, is expressly stated here,
Sure.
so
Yep.
I,
I haven't seen it.
well, I'll read it to
Yeah.
you.
A minimum of 10, I think.
Notwithstanding the above resident restriction, abutting property owners as shown on a map attached here to as Exhibit D shall be allowed access to the facility subject to a comparable fee structure and in accordance with the rules and regulations established by the association. A minimum of 10 non-resident family memberships shall be offered and a maximum of 30 non-resident family members may be allowed by a vote of the association. So, I mean,
So it's not a maximum of 10, it's a minimum of
A
10.
minimum of 10.
Yeah,
Offers.
yeah.
And are you,
If 10 people want to do it, then, and agree to the terms and the fee and everything, then there's 10. If 2 decide that it's worth it, and 30 have been offered,
It's 2.
or if everybody's been invited and And there's only two that want who are interested, then there's only two who are interested.
But are you still the majority voting member on the
Yeah.
board?
Yeah, the developer stays in control until the last unit is sold. So you've got somebody to hold accountable.
Okay. I mean, yeah, it's a sticky wicket, as they say, so. Do we want to talk about it anymore?
No, I mean, I think that they've started a process, and let's see where it ends up.
That's my feeling.
Hopefully, you're not back here.
So it would be great. We'd love to come back and report at your October meeting, whether, because it's really this initiation fee, I think that's kind of the heart of the matter here. So I think either we're going to have a meeting of the minds or not. So I think it would be appropriate to come back and maybe continue this at your October meeting.
Yeah, I
Sure.
agree.
You know, just a bit of a side or bigger picture. You know, I think having gone through this and seeing all these specific regulations that we put in, and you have no idea how they're gonna play out. You know, my approach is to look at it pretty much, look at the plain reading of what's in that regulation and not have to go through these iterations every time something comes up, because this could snowball into other things, and then we're having to look back at who said what, when, and read old tape recorder sessions to figure out intent and things like that, so.
But you signed the decision. Well, it was signed. That's what, I'm sorry, for you.
Yeah, that's fine.
That's what determines. The
Right.
minutes are informative, but
Oh, right. But and that's, in this case, I just think I try to read it as plainly as possible, and not try to read in as little as possible what was intended. And, this is, hopefully will be worked out, but I think down the road of other 40Bs where there are a lot of regulations.
It'd be nice if comparable fee structure had been further defined,
Yeah,
and then we wouldn't be having this discussion.
yeah.
Now, you could make the argument that if no one else pays a initiation fee to be part of the homeowners association, it's not comparable for an outside member to pay. But now we're parsing words
Right,
that,
and I don't want to read into it based on what's going on today. It should be read into what's going on at the time it was approved, which is, maybe it was like Jeff said, that, it was a compromise with the neighbors, and it was never anticipated that initiation fee that would be charged, not in view of now when the pool's crowded and, things have
Yeah.
changed, so that's all.
As part of the settlement agreement, page 222 of the packet, it speaks to this again a little bit. Rugged Scott also agrees to comply with condition 3.2, which is what we just talked about. In addition, will present and discuss with a representative group of butters its proposed guidelines on these matters before submitting them to the board for approval. So
so basically, you could make the argument they have to come back
that's correct.
for our approval.
That's
All right.
correct. Seems
Well,
that way.
Yeah. Jill, did you want to say something more?
I just want to make one, it's fine to use Great Harbor as an example, I think it's good, but that is a private club. And they actually did try to do something to benefit the community. The 40B, that is a tax subsidized development that, they should have even more pressure. They're supposed to be contributing to the public good. And I just wanted to, reiterate that, I think it's not showing good faith. I think we've seen this before, and in other hearings we've had about other projects with the same developer. And I just want to say, I feel like it's not showing good faith that they're not doing anything about it either until Tucker called them. And, furthermore, once that comprehensive permit, once these units are built, I think the comprehensive permit goes away, doesn't it?
No, I don't think so.
It stays in place
Yeah.
in perpetuity?
correct. In perpetuity, yeah.
But it just, again, this project's been going on for a very long time. I think it's sad that they're not trying to work with the neighbors, and I applaud Tucker for bringing it up.
Well, I thought they were trying to work with the neighbors and work this out. I mean, so, but anyway, we don't have to get into that. Both sides have said you were trying to work this out. Let's try to work it out and come back in October. I don't think we have much more to add, do we? No?
And if it's not October, November.
Yeah.
If you want to swim in the
Well, you might want to use the gym.
oh, thought you
Okay. So is this a voting issue for us?
Not at this time.
Or is this more of it's got a file number and everything?
Yeah, I put it under other business because we're not opening the public hearing for this. This is really more of a discussion about what to do to facilitate resolution.
Okay, well, maybe ultimately, we would have to open a public hearing, I guess, but right now, we're not there, so. My question was, do we need to vote to continue, per se?
No,
No.
open the hearing.
Right. So we were just discussing it amongst friends at that point.
Okay.
Okay?
One question I have is, currently, would there only be one level of membership for people that don't reside inside the property? I mean, if I didn't want to use the pool, and I wanted the gym and whatever other amenities are available, do I have to join everything?
That's the way it is for the homeowners, they get everybody.
Okay.
Okay? So, I think that ends that matter. We'll see you in October.
Thank you.
Some of us. So then, that's it for us, other than executive session, correct?
Yeah, I would rather punt the zoning administrator discussion to November when you will be here, and Lisa, it's not urgent, I just wanted to do some clarification of protocols for that. It's kind of need to do it every 2 years, when certain situations arise with those. So that's fine, just punt to November when hopefully everybody will be there.
Yeah, that works. Can you all leave, please, so we can go to the next? No, I know that, but I wasn't talking to you two. I was talking to those guys. Get out.
Enjoy your cookies,
Yeah.
take the cookies.
No.
thought you'd come back anytime.
That's on a tape.
You
That's
take the cookies, Ed, and
Mr. Chairman, that's on the tape recorder.
Hey, Josh and Tucker, can you guys take it outside, please? Thank you. All right, so we're going to go into executive session, correct?
Yes, but I have to make sure that they're gonna turn it, you can do the motion now.
I'll do the motion.
Motion in public, then let me know and I'll turn everything off.
Got it.
Oh, you can do
do
that?
the motion.
Yeah.
Okay.
Okay, the board may entertain a motion to go into executive session under General Law C 30A, blah, 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 for the purpose of discussing strategy with respect to litigation, which are known as 1, Rugged Scott LLC versus Nantucket Zoning Board of Appeals, Housing Appeals Committee number 2018-01, and concerns a comprehensive permit so as to allow a garage to be placed upon Lot 27 Beach Plum, also known as 8 Blazing Star Road, an affordable lot for the benefit of and for the purpose of serving Lot 28 Beach Plum, also known as 1 Blue Flag Path, an adjacent market rate lot. And 2, Rugged Scott LLC versus ZBA, Housing Appeals Committee number 2018-04, which concerns a denial by the ZBA of a request by Rugged Scott LLC to modify the Beach Plum comprehensive permit so as to allow garage built on Lot 24 Beach Plum, also known as 12 Blazing Star Road, an affordable lot to be used for the benefit of Lot 23 Beach Plum, also known as 14 Blazing Star Road, a market rate lot, because an open meeting discussion may have a detrimental effect on the litigation position of the board. So, that's the motion, I guess, or that's not the motion, that will entertain that motion. Can someone make that motion? Do we go into executive session?
Yes.
Jeffrey?
Make that motion.
Second it? Michael seconds it. Any discussion?
No.
All those in favor say aye. Aye.
Aye. Oh,
Or
do we
should
have
that be
to-
roll call?
Roll call.
Jeff?
Yeah.
Aye.
Michael?
Aye.
Edward? Aye. Jim?
Aye.
That was unanimous. Okay. So we're in. All right, so I'm just gonna read the,
What are you reading?
You're gonna wait.
Okay, the sound is off.
The red light's still on.
That's yeah, they're recording, that's just video. The sound is off. Okay. That's what you want off. Unless they're fantastic lip readers. Just remind me to turn it back on when we're done. Okay.
all right, this is from George Pucci, dear Susan and Eleanor, in connection with the executive session you've scheduled for September 12, 2019, this will serve as a status report for the above-mentioned appeals, both of which are pending as attached. Rugged Scout 1. The garage at issue has not been constructed on the lot of issue. This is the Zekas now. As an affordable lot owner, Zekas, and the appellant, the market rate owner, continued to negotiate a potential resolution and then sought several continuances of the act proceeding to continue discussion. A further telephone status conference is scheduled with the presiding officer for Friday, September 13th, 2019. I will take Glenn if they reach a resolution, along with advice if the resolution is required any further proposed action by the board.
Please, no. Sorry? We're in executive session. Oh, I'm sorry.
Rugged Scott, should we take them separately? Let's take them separately. So you heard what George just said, the Rugged Scout one. Doesn't sound like there's anything for us to discuss, just letting us know the plotting through the process. I, for one, was surprised that they had had a resolution, but that's long. Rugged Scott 2. In this case, the garage has already been constructed and the affordable lot owner, Wadi, adamantly opposes any settlement. The appellant has filed for summary decision arguing the board should grant the requested modification. We filed in opposition and request that the appeal be dismissed for lack of jurisdiction, arguing that the act lacks jurisdiction to modify a permit condition where the appellant has failed to show the condition renders the project uneconomic. I expect a decision within the next several months and will update you when I receive it. It's pretty straightforward to me. It's plotted through the process. He's not looking for any input from
No,
us.
we just wanted to take a courtesy vote. It's been a while.
Yep. And, that's that. Does anybody have any questions about that?
not return
Okay,
open
Got you.
session,
That's
which you didn't
exactly
do. So now
right.
you're back in open session, now you got to close.
well, next time we do that, we'll remember to do it.
Yeah. Okay, so can I get a motion
I'll
to
make that
adjourn?
motion.
Thank you.
I think Jim's already made it.
I already made it.
Oh.
I'll second yours.
Okay. Have it, have it your way.
Do it?
Any further discussion? No. All those in favor say aye. Aye.